Down in the city, where the shadows grow so tall, there's a woman named Karen, caught up in it all. They say she did wrong, but the truth's hard to find, 'cause the law's got dirty fingers and justice is blind. Whoa, justice blues in the pale moonlight, when the one sworn to serve you don't do what's right. Whoa, justice blues, it's a cold hard fight in the dark of the night, where corruption takes flight. They twisted her story, turned the facts all around, made her out to be guilty on shaky ground. Evidence vanished and the lies start to flow, but the deeper you dig, the darker it grows. Oh, justice blues in the pale moonlight, when the one sworn to serve you don't do what's right. Oh, justice blues, it's a cold hard fight in the dark of the night, where corruption takes flight. She cries out for fairness, for a glimpse of the truth, but the powers that be, they ain't got no proof. The badges and the ties, all woven with deceit, in this twisted tale, it's the innocent they cheat. Oh, the courtroom whispers and the gavel strikes down, but the air's filled with tension neath that judge's frown. Karen stands there strong with fire in her eyes, for she knows deep inside the real crime's in disguise. Whoa, justice blues in the pale moonlight, when the one sworn to serve you don't do what's right. Whoa, justice blues, it's a cold hard fight in the dark of the night, where corruption takes flight. One day the truth will rise like the sun in the sky, and the lies will crumble, no more alibis. But until that day comes, she sings a mournful tune of the justice blues neath the pale haunted moon. Out for fairness, for a glimpse of the truth, but the powers that be, they ain't got no proof. The badges and the ties, all woven with deceit, in this twisted tale, it's the innocent they cheat. In this twisted tale, it's the innocent they cheat. In this twisted tale, it's the innocent they cheat.
Hey, everybody. Good morning, good afternoon, good evening, good night. Whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, however many times you plan on doing it. I don't care what it is, as long as it's not running over someone in reverse at 24 miles an hour, sitting 30 feet into the air with only a little scrape on their nose and a little cut on their head. So, hey, if you're not doing that, I'm just happy you're doing it here with me. Thank you very much for being here. We are in the home stretch. It is the beginning of the end. This is the final countdown. We've got closing arguments by the lawyers on day 31 of the Karen Reed murder trial. And then we've got jury instructions. And then the jury is going to deliberate. Will they come back with a verdict today? Don't know. I think it's very possible. I think it's never predict what a jury is going to do. So I'm not making a prediction here. I'm just saying my gut feeling is that they'll have a verdict today. Just my gut feeling. But now I'm asking you to predict what the jury's going to do. With our like and subscribe poll, everybody. We've got the like and subscribe poll already locked and loaded and ready to go here. So make sure you go on there. Make sure you hit the like button. We got 300 of you waiting for the closing arguments already. That's a fantastic number. That is super cool. Thanks. You could be watching anybody. You could be doing anything. You'd be sleeping, having dinner, whatever. But you've chosen to be here with me, and I'm extremely grateful for that. So tell your friends and get your friends on over here too. Make sure you hit that like and subscribe button. The like and subscribe poll. How do we have 137 likes and 250 votes on the like and subscribe poll? Clearly, you people aren't getting the concept. It's the like and subscribe poll. It's right there. You have to read like and subscribe and vote before you get to the actual question. Repent, you sinners. Repent. Get down there and hit that like button for me, please. And make your prediction. Never predict what a jury's going to do, but make your prediction about what the jury's going to do. Karen Reed will be found. Okay, now this is not what you think. This is what you think the jury is going to do. You people have way more faith in the jury's system than I do, and which is weird, me being a lawyer and all. Because 3% of you, I think that's very generous to the jurors. 3% of you say guilty. 87% of you now say not guilty, and 11% say hung jury. I'm hoping for a not guilty. A hung jury would be the worst possible scenario that I could reasonably expect, and it just takes one on either side to screw things up for everybody. We'll just have to see how it goes, but I'm hoping for a not guilty. That's what I personally think it should be. But whatever the jury does, who knows? But I'm hoping they'll come back with a not guilty too. If it's guilty, there'd be riots. Who exactly is going to riot in Canton, Massachusetts? Everybody come together. Oh, I disagree with the jury's verdict. Shame on you, Judge Bev. You're a bad human being. I suppose that's going to be the extent of the riots. I don't know where that came from, but there you go. Just confirmed that Brian Albert is in the courtroom with the O'Keefe family. Well, it'd be weird if he was in there with the with the Reed family, wouldn't it? Hey, Jules, how you doing? All right, we got a couple things to do right here out of the gate. Sonny or Chris is already gifted 5 Legal Vices memberships. There you go. If you got one of those 5 Legal Vices memberships, make sure you give Sonny or Chris the super special thanks. That makes him the Vice Racks of the day so far. If you want to unthrone him, it's gonna be more than $25. Oh la la! Hey, what's up? All the way from France. How you doing? Howdy from hot Paris, Jeff. Let's go. Well, I thought Paris was always hot, but anyway, just saying. All right, let's make sure we got the court stuff going here. Let's see. Right, they haven't started their camera yet, even though they're only 2 minutes out. So let me refresh it just to make sure it's not me. And while I'm doing that, everybody go right over there to the top of chat. And you'll see that there is a pinned comment. That is degenerate your, sorry, I just had 3 thoughts go through my head. Let's take them one at a time. Remove Sonia or Chris from the thing. Bring up the, yes, I had to refresh the screen. So let's bring it up and put it here in the minimized section, so that we can see it and we don't miss it. And the third thought was right up at the top is the pinned comment for the Generate Your Bingo card. Join us. Click on that link. Click Generate Your Card and join us for Karen Reed Murder Bingo. This is your last chance, probably. These closing arguments, I would imagine we are going to hear just about every single one of these. Maybe not what, if any, or who, if any. I'm guessing we won't hear who, if anyone, or what, if any. I'm guessing those are probably and maybe a lip smacking witness. Okay, there's a few we won't see, but we're going to see most of these during closing arguments. I'm almost certain. So generate your bingo card and play along with us. We do that so that it causes you to pay a little bit closer attention. It pays you to listen to what's going on. And you hear a little bit more than if you were just, spacing it out and listening to me in the background. Let's see what else we got going on here. I've got my caffeine, little lime and Coke, or lime and Pepsi. Yeah, there you go. All right, we are ready to go. We're just waiting for the court now. That's so nice to see you. Anyway, all the way from Paris. I didn't flash you. I didn't flash your message up there. All right. Anyways, we said they're going to be doing their closing arguments. This is it. This is the last chance that they have to speak. We'll hear from the prosecution. We'll hear from the defense. Then we'll hear from the prosecution again, and then it's up to the judge. My understanding is both sides have 1 hour total for their argument. So Lally's going to have to figure out how to allocate that between his closing argument and his rebuttal argument. And we'll have to see how much of that hour that either Yannetti or Jackson uses. Something tells me they're not going to use the entire hour. Again, I have no basis in fact or any empirical evidence to support that. It's just yet another gut feeling I have. So today, as today was going along, I was kind of playing through the final witnesses' testimony in my head. Dr. Rentschler. And I was impressed yesterday. I said it was devastating. But the more I thought about it, and then I watched it twice, and I watched Lally's cross-examination of him also twice. And absolutely devastating. Some of you mentioned it in chat yesterday, but I don't think we need the conspiracy theory at this point. Just that one witness, just Dr. his name, Dr. Rentschler, just his testimony alone made fools of the prosecution. If you didn't see it, the gist of his testimony was, look, and it was, and I mentioned it a few times last night, it's not really anything that we just don't know by way of common sense, but he's the scientist telling us the specifics and the details. If you're hit by a car going at 25 miles an hour, it's gonna fuck you up. It's gonna hurt. There's going to be bruising, regardless of how little time you have left alive. There's going to be trauma to the skin. There's going to be lacerations and, subdural, like under the skin lacerations. There's going to be on the surface lacerations. There's going to be marks all over the damn body. And he was saying that if the theory is that the impact was on the back of the head first, he would have to be in such a weird position that not only would it be nearly impossible to squirrel yourself in that position, but you would, when you're hit by the 7,300-pound vehicle, it would also snap your neck and do amazing amounts of trauma to your spine. Then he took well, what if it just hit your arm? He said, well, yeah. The problem with the it just hit his arm theory is all of the scratch marks, all of the abrasions on his arm were uniform depth. There should have been amazing amounts of plastic embedded in. We didn't say amazing amounts. There should have been plastic embedded into the wound. They should have been deeper. They should have been less uniform. And even if it just hit his arm, even if he just stuck his arm out, one, it's not going to spin him around 30 feet. And two, it would completely destroy his arm. There would be broken bones, ligament damage, tendon damage. No matter what you do, no matter how you slice it, being hit in the face with an SUV at 24 miles an hour is going to do a great deal more damage than was present on O'Keefe's body. So yeah, and then Lally, I did not understand. And the more I watched, the 3 times I've seen his cross-examination, the less it makes sense every time I watched it. His cross-examination was some of the best testimony for the defense that I heard in the entire trial. He sort of confirmed everything. Every theory he threw up, the guy just knocked it out of the damn ballpark. It was bad. It was really bad. But it seems like court is a bit late today. So what are we gonna do? Send Strawberry some love. Strawberry, sending you some love, Yoda. Don't love Strawberry that much. There you go. Hey, buddy, what's up? Hey, dogs, you're getting love sent to you. Choose life, choose Jeff. That's me. The issue is that the jury only gets to see it once, though. Well, that's why we get the closing arguments. They get to remind the jurors of what they saw and cue them in onto pieces of evidence that they should look at during their deliberations and things like that. Hopefully, hopefully, and Eddie or Jackson does a good job. They're going to do a good job. They've had a little bit of time to prepare. So I'm thinking while we're waiting, the best way to make trials start, the best way to make the hearing start is to do something else. So I'm going to bring up, we'll bring up Rentschler's testimony again. Quick poll while I'm doing that, people. 1 in chat if you want to see the direct, 2 in chat if you want to see Lally's cross-examination. Which is it going to be, people? 1 if you want to see Rentschler's direct, 2 if you want to see Lally's cross-examination. And while you're doing that, I'll be bringing this up. Let's see here. Law and crime. Oh, looks like cross-examination is winning. I'm surprised. All right. Let's see. Yesterday, all of Lally's trouble seems so far away. All right. Day 30 morning. There we go. All right. I just happened to have it ready for him because I was getting ready to watch it the 4th time. All right, people. I'm going to keep an eye on the court here, and when it oh shit. Hang on. It just went black. Nope. All right, we're still good. Scared me. I thought it was paused and we'd missed something. Right. So let's do this. We'll bring this out and we'll bring up yesterday's cross-examination of the final witness, Dr. Rentschler, the biomechanic guy.
They have a moment. Yes.
All right, this is. Here goes Lally.
Good afternoon.
Good afternoon.
Now, you, in conjunction with the other doctors on your team that conducted the analysis and testing in this case, you wrote a report, is that right?
We did, yes, sir.
And that report, excuse me, was issued on February 12th, 2024, is that correct?
I believe that's correct, yes.
And within the first paragraph of that report, the last 2 sentences state, this analysis is based on information currently available to ARCA and is only to be limited, only to be issued in its entirety. However, ARCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
I believe that's correct, yes, sir.
Now, the information that you received and that you reviewed either
Interesting. Huh.
individually or as a team.
All right, I'm having this cool little glitch thing here. If I can't have two YouTube windows open at the same time. That's extraordinarily odd. Huh. All right, that's a bit different. That's never happened before. Yay, settings. Huh. Right. Let's try this again.
That included
Nope.
some
Weird. Huh. That's extraordinarily interesting. Anyway, I guess you just got me talking to you then. Well, shit. Oh, wait, I think I have a workaround. It's going to take me a minute, but it looks like we got nothing but time while we're waiting for the court. I wonder why it does that. It's never done that before. Huh. Oh, we've got some noises going on in court. How? I'm sorry. That's just weird. We're just killing time here, so hang tight. Law and Crime will bring up today's on a different browser. So, how y'all feeling today? The issues that, okay, let's see. Butt time, what? Workaround? No. I think YouTube did some things. I noticed other stuff earlier. Yeah, it seems like YouTube is doing stuff. Because for some reason I can't have two windows on the same browser, two YouTube windows on the same browser playing right now. And that has never happened before. So we're dealing with it here while we bring up yesterday morning again. And we'll bring that. We'll copy that over here. All right. And then I will bring up the today's proceedings over here. All right. Now we're good to go. We're on separate browsers. We got one on Edge and we got one on Chrome. So this is Lally's cross-examination yesterday of the final witness.
Reports, is that correct?
Yes, sir.
Some Canton Police Department reports, correct?
Yes,
Some scene photos, is that correct?
that's correct. Yes,
Medical examiner dispatch removal report, is that right?
I believe so. Yes, sir.
Some videos from the location of 34 Fairview Road, is that right?
Yes, sir.
Some
These are the
photographs
things
of the
that
defendant's
they
vehicle,
looked
the
at when they were
2021
making their
Lexus
report.
LX 570, is that correct?
Yes, sir.
Photographs of evidence that was recovered from the scene, is that correct?
That's correct. Yes.
CDR report from the defendant's Lexus.
Yes, sir.
And then essentially there were some other materials, whether they be literature or other things that you and your team of other doctors reviewed over the course of formulating your opinions in this case, correct?
That's correct. Yes, sir.
Now, in regard to evidentiary materials that indicates within the report that were reviewed, you talk about the lens cap to the taillight assembly, the taillight assembly photographs of that nature, and then there's mention of a black straw that was found on scene, correct?
Yes, sir.
There's no mention in the report of either Mr. O'Keefe's shoe or his hat, correct?
Yes. You are muted.
All right, we don't need to be up there while they do that. And he asks a lot of completely useless information during his cross-examination, like the black straw. And again, thank you very much to O'Keefe's brother for covering up his junk a substantial amount of the time. Come on. Come on, Lally. Ask your questions.
Are you familiar with a term called compression abrasions?
Compression abrasions?
Yes.
Yes.
Yeah, we don't
Am I
call it
correct when I
that.
say compression abrasions are essentially when direct pressure from a blunt object together with slight rubbing movements produce skin and epidermal crushing? Is that what your understanding of the term is?
Yes, sir.
And you're familiar with patterned abrasions?
I am. Yes.
And pattern abrasions are injuries that show a distinct pattern that may reflect the shape of the impacting blunt objects that you may see with reference to injuries that are left by that blunt object. Is that correct?
That's correct. Yes, sir.
Now, as far as in general terms, from what you reviewed, at any point in time, did you look at a state police reconstruction report?
I don't believe that I did, no, sir.
You weren't provided with that, is that correct?
That's correct. I don't believe so.
You weren't provided with any sort of forensic reports, DNA or anything like that, is that correct?
I don't believe so, no, sir.
And you never actually looked at the physical car, is that correct?
I did not. That's correct.
And you're aware that the physical car, being the defendant's car, is still in law enforcement custody and available for inspection if you had wanted to? Are you aware of that?
I think I'm aware of that, yes, sir.
You never made that request, is that correct?
That was not necessary in this case to inspect the vehicle.
Whether it's necessary or not, you didn't make that request, correct?
See, that's
Yeah, I don't remember if we made.
it's not you could have done this. Well, it's not necessary. It's not necessary for what we do. Well, whether or not it's necessary, you didn't do it. Yeah, well, it's not necessary to punch you in the face, and he didn't do that either. Would you like him to do that, Lally? Well, whether or not it's not necessary, you didn't do it, did you? That's the stupidest comment.
Made that request or not, we obviously didn't look at the vehicle, but it wasn't necessary in this case.
Did you ever look at the actual taillight pieces or the taillight housing, is that correct?
Not the actual. We looked at photographs of the evidence. Yes.
It's like he doesn't understand what these people do and what their mission.
The injuries that you observed or reviewed in materials in regard to Mr. O'Keefe were primarily on the right side of his body. Is that correct?
Well, sir, on the right arm and the posterior aspect of the right arm, yes. And then the skull fracture was a little bit to the right, the occipital fracture.
Also bruising on his right hand. Is that correct?
There was bruising on the back of his right hand.
On the
Yes.
dorsal aspect.
They were
Yes,
tasked by,
correct.
they were
There was
hired
also
by
bruising
the.
on sort of the
I guess
posterior.
we can pause it now. They were hired by the FBI to reconstruct the accident. His buddy was tasked with reconstructing how the damage to the taillight likely occurred, and he is tasked with seeing what would happen to the body. Are the injuries to John O'Keefe's body consistent with being hit in the face by an SUV? So that's what the FBI hired these two guys to do. And that's all part of the FBI's investigation into the prosecution of Karen Reed.
Or its right knee. Is that correct?
There was a
Well, that was the wrong button, wasn't it? There we go. That's what I wanted to do.
Now,
Well, that's
with
what
respect to,
they
within
said they were hired
your
to
report,
do.
you talked
So
about
hey,
the numerous linear
The FBI
abrasions
hired
on
them
the
to do that.
posterior of Mr. O'Keefe's right arm and forearm, correct?
yes, sir.
And in relation to those injuries, there is a sentence in which you or whoever authored this part of the report, assuming it's you, indicate that furthermore, any such injuries would be highly improbable if Mr. O'Keefe was wearing a jacket, correct?
Yes, sir.
Are you aware that Mr. O'Keefe was not wearing a jacket other than a long sleeve sort of hooded shirt?
I believe that came to light afterwards. Again, it doesn't affect my actual opinions in this case, but it was a sentence added in there. Yes, sir.
And so also within your report, same paragraph, you indicate blood and DNA transfer would also be highly probable under such circumstances, none of which were reportedly found on the tail lamp assembly or any of.
Okay. Well, this actually isn't their deal. They do all kinds of cool things, and one of the cool things is which they talked about during the voir dire is a lot of what they do, he said, is with sports, with the sports biomechanics, and they were hired by the NHL to figure ways of minimizing injuries to hockey players. And one of them was the redesign of the glass around the players' boxes and the penalty boxes and things, because one guy damn near got killed getting checked into the glass at one point. So yeah, these guys, they're just the top of what they do. They're the best at what they do. So if they're good enough for the FBI to hire, then they must be pretty good at what they do.
The fractured pieces, correct?
Correct.
Are you aware that DNA consistent with that of Mr. O'Keefe was actually found on the taillight housing from the defendant's vehicle?
I'm aware after we wrote or issued the report that it became known to us that I believe DNA was tested and some DNA was found, I believe a small amount. I don't believe any blood evidence was located or found on any pieces, but there was indication of DNA on the taillight housing.
There was also DNA matching Mr. O'Keefe that was found on the exterior of a piece of drinking glass that was found right near his body.
I believe so, yes.
And there was also pieces of approximately 1/16 of an inch by 1/16 of an inch of clear and red plastic.
All right, the judge is making her way into the courtroom, so enough of this. Oh, and of course, as soon as I do that, judge called for a sidebar. So put that on your bingo cards, people. Let's see here. Let me bring up the screen. All right, the judge called for a sidebar already, so mark that off on the bingo card. Judge calls for sidebar. Where are we? Why can't I find judge calls for sidebar? Judge calls for sidebar. There it is. Free space. We're good. All right. Well, it looks like everybody's looking. They've got the whole crew there. They've got the entire rogues gallery, haven't they? Everybody managed to come to court today. Hey, you two, how do those new charges against you sit? How does the assault charges feel, guys? They're all, the whole clan is there. We're gonna get it all today. I think we're gonna come close to probably getting a complete bingo blackout during the first 2 hours of this. There's a lot. There's a lot they've got to talk about. What are those guys happy about? Notice how professional and clean cut and well dressed the Reed clan is. This guy that's on the end on the far right, he's always wearing a vest. He's always looking sharp. Everybody else is like in their polo shirts and looking like they've just come off the dock somewhere. My understanding is they did. That's what the report that I saw said. He looks like a cop. Albert Clan acts like the mafia. Well, we did see them all sitting out in front of their pizza joint on that video. Like I said, I don't like to follow the extraneous stuff, but that video just came just filling up my entire Twitter feed for a couple of days ago. And I was like, all right, who is this person and what's going on? I had to watch it 3 times. I went, okay, who is this person? I went, oh, okay. Because I was like searching Jill Daniels. I'm like, oh, there was like an actress or somebody else. I went, oh, it's Jen McCabe's sister. Oh, all right. And so then I went, all right, fine, that's cool. And then I realized what was going on. But yeah, apparently, I guess, from what they say, they got charged. Don't know if it's true or not, but that's what I read. Well, see, I don't need this up anymore. Let's see what we're sitting here on the like and subscribe poll. All right, we got 544 people here, 332 likes so far. 86% of you say not guilty, 4% say guilty, and 11% say hung jury. We'll see if that changes as the turnover happens. There tends to be some turnover. Hey, we get a ceiling Dion right out of the gate too. Boom. We're off to a good start there. There's been like 5 words spoken, and we've already got the judge calling for a sidebar and sealing Dion. Somebody bringing donuts? Who brought donuts? I want donuts. I've got my snacks prepared. Oh, the first harvest of watermelons just came in Korea. I mean, like gigantic, about 20-pound, like 8-9 kilo watermelon. I'm gonna be eating watermelon for the next 6 weeks. But it's so good. All right, just kind of scrolling through your chat here, see what you guys are talking about. Chat. So sometimes it'd be nice if you could talk about things that I could actually put up on screen and address. Oh, your wife is also, she got Krispy. See, the problem with Krispy Kreme donuts is you can eat one. You can eat one and be happy, but they're sort of like air. So it takes you about 15 seconds to eat a Krispy Kreme donut, and you're in heaven and you love it. And you think, oh, the second one, if I have 2 Krispy Kreme donuts, that'll be twice as good. And so you stuff another one in your face and you're like, ugh. That wasn't as good as the first one, but it was still sugary and delicious. And maybe I'm going to chase the dragon and have the third one. The third one will be the best. And then, so you stuff a third one in your face, then you get sick and you gain 4 pounds in the process. That's the problem with Krispy Kreme donuts. Yeah, they're good for one. You got to have more than one, and then you regret it. That's my theory of the law of diminishing Krispy Kreme donuts returns. Krispy Kreme with whole milk. There was actually a place, I can't remember where it was. Was it KFC? So one of these places made like a chicken burger with 2 Krispy Kreme donuts as the buns. I thought, do we really need that? The answer was yes. They were delicious. Worse than the mini donuts because they're so deceptive. All right, they're certainly taking their own sweet time here. I need to go get my eye drops. My eyes are just dry as hell, and I can't see. Everything is still blurry because my eyes are dry. You can just like feel your waistline increasing and your arteries clogging, but they're so delicious. Yeah, it was KFC. That was darn good. All right. Well, I'm so glad we stopped watching the cross-examination of Dr. Rentschler to look at the fan here. Jeff, if they do by chance get a hung jury, do you think the state will try again? I was thinking about that the other day. I think it's about, for me, it's 50-50. I mean, they have to because they've invested so much in it. Their reputation's on the line. They've got to do it. They can't look weak. They can't back down. There's going to be some pressure from the Albert clan. They've got to do this. But on the other hand, the public outcry by and large was horrifically against them. They got their ass handed to them so often during this that a hung jury is going to be an absolute miracle unless somebody with an agenda is on the jury. But it sounds like they got rid of the one juror that may have had an agenda. So I don't know. It's kind of a toss-up. We should do that again. What do you guys think? I'm going to throw this right back at you for another lightning poll. Let's all assume, for the sake of argument, that there is a hung jury. Put a 1 in chat if you think they would try the case again, and a 2 if you think they would just let it go. Would they dismiss? 1 for retry, 2 for dismiss. I'm curious to see what you guys think. I wish there was like a faster way of interacting with you guys, other than like multiple polls would be cool. Instead of making it so we can't look at 2 different videos at the same time, why don't we make multiple polls? That would be good. Wow. See, you guys are split right down the middle too, it looks like. Very, very close to fitty-fitty with you guys. And I'm about ready to sneeze here in just a second. So I hate this feeling where it's like it's going to be a false alarm, or are you actually going to sneeze? Let me look up at the lights. Does that help? No. I guess it was a false alarm. Okay. Who wants Lally again? Oh, I think if they retry it, I would let's assume that they do retry it. I would be surprised if they gave it to Lally again. That would be the biggest surprise. The second biggest surprise would be that they retried the case. But I think if they do, it will go to someone else other than Lally, because by any measure, his performance has been seriously underwhelming. But the state's got more things to worry about. They got to worry about the feds. They got to worry about the FBI investigation, which is still ongoing. That's the one I'm interested in. I want to see what the Fed investigation turns up and what the outcome of that is. And like I said, I know next to nothing about Turtle Boy's deal, but I know he's been charged with 11, 12, 13 counts of juror intimidation or whatever. I don't think it'll go to trial, but if it does, I might be interested in following it, because you don't see a lot of jury intimidation trials. Occasionally you'll get one thrown in, like we saw with the guy with the face mask. He was charged, I think, with witness intimidation. But you don't see a lot of juror intimidation cases. Lally's incompetent. He's just in over his head with the shit show MSP has left him with. No, he has tried some big cases before. He's not a rookie at this. He's been doing it for a number of years. This is just the wrong battle, I think. And you also kind of have to guess at what the vibe of the trial is going to be, and assign the right prosecutor to match the vibe of like I said, you don't want this milk toast, wishy-washy, hair cone of injustice, ill-fitting suit prosecutor that just kind of mumbles his way through things and just kind of doing that to be where you've got a dynamic Ian Eddie and Jackson type person. But I don't know. I don't know how we got here in the first place. So Lally has nothing to work with. He has very little to work with. And like I said, I think his cross-examination of Dr. Wolf yesterday was probably the best cross-examination of the trial. It still amounted to nothing, and it probably did more damage to good to his case. But I thought, he was on his game. It was just the wrong game. Oh, Brian Miller throwing around a $5 super chat like it's going out of style. I believe that all them being in the courtroom today is bad for the prosecution. The juror is going to see them sitting on that side. It's going to show bias. Well, it's not really going to show bias because that's the side they testified to, and they're all sitting on the side of their friend and relative and whatnot. Why I think it's going to backfire is they've all got these shitty scowls on their face. They've got these terrible expressions on their face that is going to confirm everything that the defense has been saying about them being thugs and thinking they're better than everybody else and unpleasant people to be around. We know that Jennifer McCabe, her cross-examination just showed her to be a right monster of a human being. And she's sitting up there scowling right next to her scowly husband, who's right next to the scowly other people in the family. Wolf in Indiana is pronounced woof. Yeah, we've got a few places in Utah that talk about woofs and werewolves and, and things like that. There's a few places in Utah that pronounce it that way. But again, as we know, the only true pronunciation of that most important of legal terms is Voir that's just how it's pronounced, and you will not convince me otherwise, because I know the truth. It's voir dire, people. By the way, thank you so much, Brian Miller, for that little super chat there. But I think you're right, but I would guess for a different reason, that it's going to backfire for them, all sitting there looking scowly. If I would have been Lally, I would have asked them to stay outside during the closing arguments and then to come back in after. Come back in, when the jury has reached a verdict. Frankenstein, yes. Legal Vices says Daily Quick Bites. Lally being technically good, but technically stupid and strategically stupid is stupid. Rommel and the failed Austrian artist Atlantic Wall was technically and technologically brilliant and utterly useless. Fair argument. Oh, do I still have it? I used to have that sound on my soundboard. I don't. I took it off. Dang it. Oh well. I used to have that on my soundboard. Aussie Tank with a $5. Will the Alberts and others go under investigation after this? And will they find the person who did this? Or is this what the FBI are doing? My understanding is the FBI is just investigating the investigation. They're investigating the investigators, which is why they're saying, oh, that's why they hire these people like Wolf and Rentschel to say, look, this here is in a closed sphere of facts and evidence. Does the injury to the body, do the injuries to the body match the damage to the vehicle and what the injuries to the body should be given the facts alleged by the state? So, and here's the problem with this. If they're found not guilty and they go after someone else, that is essentially a tacit admission that they fucked up the initial investigation and the prosecution. It means they never should have done it in the first place, which is why you don't see a lot of these. This person is found not guilty, so we're going to reopen the case and look for other people. They have to stick by their arguments that they got the right person, but the jury got it wrong, which means likely never going to find out who the true killer of John O'Keefe was if there's a not guilty verdict. I mean, that's just kind of the reality of it. The prosecution, the police, the grand jury people, everybody's going to have to say, we messed up. We screwed up the interviews. We screwed up the investigations. We screwed up the prosecution. We screwed up the charges. We screwed up all of this. So now let's go and find the right person. It's virtually never going to happen, which is sad and disgusting. Voodoo Berries, member for 13 months. What's up? Year and 1 month for Voodoo Berries. Juror up at the bench with judge and then walked out. Apparently she was very expressive and most upset by Proctor. My understanding was she was upset with Karen and she didn't like the way Karen was smiling and she didn't like the way Karen was talking to her family all the time. That's what I heard. But see, this is the thing. We don't really know why the jurors leave and stuff unless they come out and say, this is why we left, or someone leaks it. But I don't know. I heard something different, but you could be equally as right because, what the hell do I know? The people at 34 Fairview know who did it. I think you're correct. Well, we can't really blame the grand jury because grand juries are incredibly one-sided affairs. Grand juries, that's just the prosecution laying out just the bare minimum of the facts to say, okay, is there at least probable cause to charge these people and have a trial? So, I mean, we all know the cliche that a grand jury could indict a ham sandwich because the defense doesn't get a say. What are you grumbling about? Strawberry, are you upset? Strawberry seems to be upset because Yoda is laying on her blanket.
What do you want?
Play with your basket. I don't know what you want. I don't speak dog as much as I speak some dog, but I don't know what it means. Oh, there's a juror problem now. Okay. Who are we seeing this from? Yikes. The O'Keefes have brought Colin Albert. Okay, that's Juror number 3. Okay, this is from Turtle Boy's Twitter, I guess. Juror number 3 has walked out. After she did, the attorneys continue to discuss with the judge. Some have suggested that she may be the foreperson. I have no idea. All I know is the last time they called a juror up like this, she was kicked off the jury. Ironically, juror number 3 was also called up on that day. Juror number 5 was kicked off the jury. And sources say she reported juror number 5 for some sort of inappropriate conduct. Juror number 3 took her job very seriously throughout the trial and was alert and took notes with every witness. That's interesting. What? Some people are so dumb. Good Lord. I hope this is a joke. So, someone says, no, a jury foreperson does not get to hear closing arguments, but they do preside over deliberations after. What the hell kind of... They've got to be kidding. I'm just guessing that's a Turtle Boy shit stir because that's just ludicrous. Earlier post says juror number 3 is standing with her arms crossed 5 feet from the judge as she huddles with the attorneys. She seems upset, and it appears as if they might be kicking her off the jury. This would be an injustice. Well, yeah, come on, Turtle Boy. We don't know if it's an injustice. Maybe some shit happened yesterday that she deserves to get kicked off the jury for. Maybe something happened this morning. Maybe we just don't know. You can't say it's an injustice. Tanny Simmons, what's up, Tanny, with the $10? I could believe this was truly an accident. Drunk and he hit his head, and maybe there's panic. Then I take into account Lucky Lovren, he's the plow guy. He's Mr. Plow, and I have to believe otherwise. He was a clutch witness. I completely agree with you. He's the one that says I was there, and there weren't no body out on the front lawn. Let's see. Let's check and see if we have some other sources of information. Maybe we got something from Law and Crime, Twitter peeps. Law and Crime Daily. No, nothing there. Law and Crime Network. David Wolf. No, that was the last post they had 18 hours ago. Come on, Law and Crime. You gotta. What about you, Buck? Oh, interesting. Buck Esquire, Mr. Buck from Law and Crime Daily has had his Twitter account suspended. That's funny. Okay. All right. Well, yeah, see, this is there's more people. They had, I believe they were down to 15 witnesses, so I think 3 of them would have to leave. 3 or 4. But yeah, I don't know how they do it in Massachusetts. Maybe somebody here knows. No, they haven't started yet. There's a problem with one of the jurors. We're trying to figure out what's going on here. How do they do it? Because in a lot of places they won't say who the alternates are until it's time to begin the deliberations. In other places, they'll say, okay, you are the 12. You are the reserve. If one of these 12 goes down, one of you takes their place. I don't know how they do it in Massachusetts. Are they designated the 12 to begin with, or is it just everybody and they assign them later? I just don't know. Let's see. A reporter, not TB, is reporting that the juror is up at the bench. Lawyers are at the side. Intense convo. Judge left the bench. Juror is still at the bench. Lally sitting. Jackson standing. I sent you another courtroom sources. Woodbury's they're calling her juror number 4, though, but reporting the same thing. Oh yeah, Fall River Reporter's been pretty accurate so far. So, good morning. We're here in Norfolk Superior Court for closing arguments. Attorney Little is not speaking with Bev. All right, let's read through this thread and see if there's anything. But first, Heather Sparrow has been a member for 16 months. I was on a jury in Massachusetts. We all sat through closing. Then the alternates were picked. Okay, and we picked our foreman after. All right. So nobody knows at this point who the alternate jurors are going to be. So thank you very, very much for that, Heather. That is very, 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 very kind of you. And thank you so much for being a supporter for 16 months. Right. So this is the thread here from Fall River Reporter. As you may have heard, the O'Keefe family has invited Brian Albert, Colin Albert, and Jen McCabe to sit with them. Members of the Reed family looked disgusted as they took their seats. Karen Reed's brother laughed. We are waiting quietly for both the jury and the judge to enter the room. It seems surreal that this is finally happening. I've tried to provide unbiased coverage from the start, but I fear my emotions may take over today. Bear with me. All right. I spoke with supporters outside this morning. Many first-timers here. Everybody wants the verdict today. Well, if they get their shit figured out here, I'm confident probably isn't the right word. I would not at all be surprised, and I would expect a verdict today. Judge has arrived and has called a sidebar to start. I was so nervous I missed Bev's shoes. What? The jury's not here yet. Not sure what is going on, but Bev has called multiple court officers over to speak during the sidebar. The pool camera was instructed to OMG. Juror number 4 has just walked in. She walked straight over to Judge Canton. Juror number 4 is speaking to the judge directly. I cannot believe what I am seeing. How long ago? This was 18 minutes ago. I've noticed her shaking her head no several times. She has stepped aside and has her arms crossed. She seems mad. Bev is speaking with both sides right now. Juror number 4 is standing about 10 feet away from the press box, leaning up against the wall. Her arms are crossed at her chest. 16 minutes ago, Bev has called the court officer over. He is taking juror number 4 out of the room. The sidebar continues. 16 minutes ago, also, Yannetti is standing closest to Bev and speaking right now. I have not seen Lally say a word. Attorney Little is not speaking with Bev. 13 minutes ago, Bev keeps shaking her head side to side as she speaks. Sidebar is over. Judge has left the room. Karen and her team are huddled at the table speaking together. All right. Huh. Well, that's interesting. Nah, there's no mistrial incoming. There's alternate jurors. No idea. And the chances of us ever finding out are pretty slim, actually. Unless someone talks. All we're going to hear from the judge is, you're not to make any assumptions. Sue from the Boston Globe reported the juror to the bench is the same juror that reported the other juror the last time. Okay, that's what that coincides with what Turtle Boy's Twitter said. Albert party afterwards with another sacrifice. Oh, that's a horrible thing to say, Jennifer. Huh. Mystery. I'm a fan of this channel. See what you did there. Do they sequester juries anymore? It's got to be a pretty intense case, a pretty special case to sequester jurors. I don't see any reason they would. Well, in this case, maybe, I don't know, but there hasn't been any mention that they would sequester the jurors during deliberations. But SampXZ says if Karen is found guilty and the FBI comes back saying the investigation was bad, does her conviction get overturned? Well, it could on appeal. That would, if there's some sort of conclusion from the FBI, and if it has any weight and people get in trouble for it, that would certainly give additional support for the matter on appeal. Do you remember the movie Jury Duty? I don't think I ever saw it. No, if you check out all of the information here, people are still asking if the closing arguments have already happened. No, nothing is. Where are we at here? Nothing has happened yet. We're waiting for the arguments to start. All of the information is always scrolling across the bottom of the screen. We are waiting for closing arguments to start. Jury problem right now. All right, looks like
Goes back to session. You may proceed.
All right. Oh, now we're gonna have another sidebar. All right, whatever, Bev. You do you, Bev. Now we'll find out. Let's see if we get any more info here before we start. Judges back, sidebar. The press has been talking and none of us have any idea what's going on. I've seen Peggy O'Keefe laughing in the front row. Not sure what that's related to. All right. Bev is talking to everyone. She has some papers in her hand and has her glasses on. All right. So I guess the first thing we're going to hear about it is when the judge makes a deal about it or doesn't make a big deal about it. And then I need to get my damn eye drops. Have a sidebar to end the other sidebar? Is that like the National Guard setting a backfire to stop another? Could be. Could be. What do you want, Straubs? I don't speak dog. I don't know what it means. I don't know what Strawberry wants. I don't know what you want, buddy. You just want some love? Is that what it is? You just want some attention? You just want some scratches? Okay, we can give you some scratches. Everybody gets pudding, says Jesse McCloverty. Seriously, Tammy Faye, it is Wookiee speak. It's totally Wookiee speak. Now I'm never not going to hear Wookiee every time Strawberry whines like that. Yeah, I know. It just seems like she wants pets. She's just sitting in the corner being ignored. And Yoda's passed out on her blanket. So I think she's a little put out by that too. Let's see, they're looking all scowly faced and concerned. Oh, hey, I just got a notification, an emergency notification from the Korean government that North Korea is launching some more shit balloons. Yay. They're launching some more filth-filled balloons and sending them down South Korea way. Isn't that good? these are, you know, they send you these emergency notices. You think, oh my gosh, is something terrible happening? Like, oh no, they're just launching some shit balloons at Seoul. We're good. The floating feces, yeah, it's the shit balloons, Mr. Leahy. Okay, so we had a very, very long sidebar, and then we had a very long delay, and now we're having another very long sidebar. Well, isn't that just fantastic? Let me refresh my screen here and see if we get some more information from Fall River Reporter. Karen is leaning. Well, no, we can see Karen is leaning forward in her seat. That doesn't help. I think we've seen many sidebars throughout this trial, and I have never seen the defense so serious. Yannetti is closest to Bev and is speaking to him directly. Female from the Commonwealth is taking notes. Bev's talking to everyone. Oh, okay. Huh. This is kind of interesting here. I thought I heard Bev ask something that sounded like, what time would you like to? But don't quote me on that. All right. Okay, we got a good courtroom view here. They never show the lawyers huddled up there by sidebar. I guess they don't want people reading lips or whatnot. This is very interesting. This is not something you see. Is things going to shit right before the closing arguments? Who are you talking about needs hugs, Strawberry or Jen? Definitely Strawberry. Definitely Strawberry needs the hugs. You need the hugs and scratches, huh? Yeah, we don't have any for Jen. Sorry. All right, what are we? I'm just curious. I'm fascinated. I'm just okay. No more updates from Fall River yet. All right, I'm not seeing anything from anywhere else either. What are we thinking here, y'all? And behind the times, there's something going on with one of the jurors. One of the jurors has been called to the bench, was defiant about something, was escorted out. I don't know if they came back in or not, but the judge took off for a while, then came back, and there's another sidebar. Nothing has happened in the last hour. Can you believe we've been doing this for an hour already? We've been doing nothing for an hour. Huh. All right. Let me see. Oh God! Now is the jury coming in? Let's hope the jury is coming in. I don't know. Let's see. Boston Globe is reporting that Judge Bev is only talking to defense lawyers right now. This is just getting curiouser and curiouser. Bev has called for the camera to go up. Yeah, we know that. She's called for either a juror or the jury. Court officer just left. He's the one who brought in juror number 4 earlier. Juror number 4 is back. She is back at the sidebar with hands on her hips. What is going on? What is going on here? This is fascinating. Huh. Didn't have this on our bingo card, did we, Smarty Pants Lorax? Didn't have weird shit goes down immediately before closing arguments, did we? Did we? Man Bear Pig, what's up, Man Bear Pig with the $5? How'd the FBI get involved to begin with? Intellectual exercise, or was the MPD under some consent decree that required their intervention? I don't know how they became involved. But I don't know if someone filed a complaint or what. I honestly don't know how the FBI got involved. I just know they are. Jeff Doggo Cam, in good time. We're still a ways away from that yet. I'm sure it will happen at some point. Where on earth? It seems that something didn't get tagged. Island, where's your super chat? There it is. Nope, that's not Islands. Islands was after that. There we go. Island with also the $5 super chat. I have big plans to forget the McAlberts exist. A mistrial is not acceptable at this point. It will break my brain. Oh my. All right. This is it's being squirrely. Of course. Let's see. Sonia or Chris has gifted 10 Legal Vices memberships. Well, now we're at Doggo Cam. that got us there. Thank you so much, Sonia or Chris. That is incredibly super generous of you as always. Let's do all the stuff, shall we? Thank you. First of all, you get a big foghorn. We have to give you the big Lorax foghorn. Ooh, thank you so much for the 10 gifted memberships. Make sure you give Sonia or Chris a super special thanks if you've got one of the Cajun Legal Vices memberships. That would be super awesome if you would do that. And ooh la la, Pat, 10 euros for the doggos. We've got the doggos. The doggos are here. We just have to release the hose, which I will be doing now. No, again, that is entirely the wrong button. I'm gonna just have to unilaterally say, hang on just a minute and go get the eye drops I needed an hour ago. Let's see. This is what we want to do. Present extra camera. That button there. Share that. Pan up so we're not just looking at Strawberry's butt. Yoda has just left to go sleep on the sofa. So it's just Strawberry's behind that's joining me right now. So there you go. Have some Strawberry butt. Xcomer Triple Z with the Fitty Nokia monies. Thank you so much. Was not the guy being murdered an FBI informant? Which is why they framed Reed. Well, that might be stressing. That might be stretching it just a little bit, but thank you so much, Xcomer. All right. Don't know why the super chats aren't being automatically tagged as they usually are. It's another failure in the system. So if you do super chat at some point and I go more than 10 minutes without showing it up on screen, please type lots of messages in all caps to get my attention. Let's see. Let's check on the next Fall River thing. Some of you are saying Turtle Boy is saying the juror was dismissed. So we don't even know which juror it is because, okay, juror. See, Fall River reporter saying juror number 4 has been dismissed. But that was right now. And then 1 minute ago, sidebar continues. Bev is talking and making movements towards where the jurors sit. It seems as if she's talking about them. Jackson has just looked over at the press box. Sidebar is over. Judge has left the room. Juror number 4 has been dismissed. All right. No, it couldn't be 3 and 4 because there's only one of them up there. So Turtle Boy saying 3, Fall River Reporter saying 4. Doesn't matter. It's the same person they're talking about. The number doesn't matter. So yeah, the number doesn't matter. Somebody's been dismissed, and they got to work it out, and then they will hopefully get started. Huh. I must admit, I haven't seen anything quite like this, right? So hey. We've got 646 of you here right now watching the fan spin, whilst we figured that one juror has been dismissed. We don't know why. We don't know exactly who. We just know that from what has been reported, that the prosecution was fairly quiet. The defense was more engaged, and it seemed to be a bit feisty. The dismissed juror was reported as standing there with arms across on chest, and then later with hands on hips. So, and again, the only thing I'm expecting to hear from the judge is you're not to make anything. You'll notice one of the jurors is gone. They've been dismissed for personal reasons. You're not to make anything out of them no longer being here. Mr. Lally, whenever you're ready. That's kind of what I'm expecting to hear. I wouldn't expect anything more than that. We'll just have to see what comes out in the coming future. Come on, people. We've had enough here. We got off to such a very good start on the bingo card with 2 bingo spaces being filled with only about 5 words said, but now we saw that it was actually for a not very good reason. I mean, a reason that is not good. It was obviously for a good reason. But if you are following at home, if you have generated your bingo card, judge calls for sidebar and sealing Dion are what you should have marked off. And if you want to play along with this and you haven't already got your cards, go over there to the link that's pinned in the chat, generate your bingo card, and play along with us at home. Oh, yeah, and we got dog cam, too. So dog cam, judge calls for sidebar, and sealing Dion. And I'm getting to sleep an hour later than I had planned. That's great. I've got snacks, so we're good. Hey, Flux, what's up? Of course, all this goes down on closing day. Right. It's kind of weird. I've never seen anything like this. Well, just kind of reading through chat here, seeing what you guys think. Let's see. Let's check back in on Fall River and see what's happening in the Fall River Reporter. Nothing since juror number 4 has been dismissed. Lots of people commenting on it. All right. I'm seeing nothing of any further light and knowledge from anywhere else. So, dang. We'll just have to wait and see, won't we? Good morning. Okay, good morning. Morning. Juror number 4 has been. Okay, that's the last thing they've got. It's juror number 4 has been dismissed. Not sure why it's taking us so long here to do this. I bet the juror was caught having done outside research. Who knows? It could be literally anything. So if the juror is dismissed, are they still restricted from talking until verdict is reached, or can they spill to the press now? Well, they're not on the jury anymore. They can kind of do whatever they want. I mean, there's not much to talk about yet. I guess they could talk about what other jurors are doing, but that would be dumb because all the other jurors would hate them. Well, they got 2 more hours, then I got to go and watch it later. Oh, we got audio. Are we back? Please don't call for another sidebar.
All persons have any business before the Honorable.
All right, we're getting underway.
Superior Court before the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed.
All right, good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. I don't know how many times I start in the morning by saying we appreciate your patience, but today is one of those days. Again, we appreciate your patience. You may notice that one of your fellow jurors is not sitting with us today. I can assure you that that is because of an issue that is just personal to that juror and has nothing to do with any concern of any of you. So please disregard that. Okay?
Yeah, I'm thinking probably not.
I do have to ask you those 3 questions. Were you able to follow?
All right. While she's doing that, I'm going eye
eye
drop hunting. I'll be right back.
We left yesterday. Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So now we're at the point of the trial where the lawyers get to do their closing arguments for you. I've given them each an hour to do so, and they both tell me that they want me to give a 5-minute warning. I just don't want you to think I'm scolding them when I give a 5-minute warning, so we'll let them do that. When I was a trial lawyer, I tried a lot of cases in this courtroom. The thing I liked least about the trial was just before I stood up to give my closing argument, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. So because of that, you have to put your notebooks away. All right, so if you just put your notebooks away and just listen, and though the closing arguments are not evidence, they're certainly a very important part of the case. And we've all seen how hard the lawyers have worked for this long period of time. And we've all noticed that you've paid great attention throughout the entire trial. I'd ask that you extend your courtesy to the closing arguments. And in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last. So we will hear now from Mr. Jackson.
Thank you, Your Honor. Look the other way.
Interesting.
Look the other
Normally
way.
it's prosecution.
4 words
Defense prosecution.
that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. but it's the greatest responsibility we have as citizens here in America, lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left.
That was
They'll
good.
magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Reed. They desperately resorted to calling witnesses to talk about Karen Reed and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up until the time Karen Reed dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial. It was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data. Look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monatomic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie. And Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They'd been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course.
Pining.
It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, you know, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done.
That's my theory right
5
there.
seconds, 10, doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted that I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, and just in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't you? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it.
He's going to do it now.
Let's test that out.
He's going to do it now.
Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe? But the odd behavior isn't done yet.
It's a little more dramatic than I was expecting.
5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabes, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John. He walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't. Panic and abject fear.
Sorry about that.
She's so distraught. She reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears were realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You can see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Canton.
Yep.
He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention. And they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit.
Ooh, this could be ugly.
If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time
Yeah.
bringing in
This
experts
hair, this hair has me
mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. A magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that
other two people.
DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces. No tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that we saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Juror Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There's no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mulaney, Michael Lang, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. And they even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who. But he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about. Those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not stop and shop bags, thank God. At least they've moved up from that.
Ooh, brutal.
They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have, had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers and Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence. And now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. Because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science.
Talking for weeks about the
Let's
snow.
talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but 2 thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner, who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. 2 of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rinchler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony.
Oh
I
yeah,
think
we
I'm being
remember.
kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacked
But he
the
studied
experience,
forward
the education, the training, the background, and
and
the
stuff.
knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement, before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable.
No, it doesn't
Compare that
border on
testimony
laughable.
to
It
Dr.
is
Dan
laughable.
Wolf and Dr. Andrew Rentschler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rentschler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, "You can't deny the science and the physics." John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
Five minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? With this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted. Will that continue? And the answer should be not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat. Talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object and went further by insulting her. He went further than insulting her and dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you, not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that, which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth, and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
Thank you very much, Mr. Jackson.
Damn.
All right, Mr. Lally.
That
Thank you, Your Honor.
was a fantastic closing. Oh my God, that leaves a lot for Lally to make up for here right now. And let's see what he does with his hour.
I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag, valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened, and the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Famati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, "Oh my God, I hit him." Firefighter Katie McLaughlin was tasked by firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant, and the defendant said, "I hit him," repeatedly. Firefighter McLaughlin asked for clarification. "You did what?" And the defendant repeated, "I hit him." Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, "Could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him?" Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, "I hit him." You heard testimony from Officer Sarah, statements that he attributed to the defendant as saying that morning, "This is all my fault. This is all my fault. I did this." This is what the defendant is saying on scene. Since then, stories changed a little bit. But those were the words that came from the defendant's mouth on January 29th, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case. Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a three-card monarchy. Facts and the evidence in this case are your card, they're the Queen of Hearts. And so what I want you to, or what the defense wants you to do is not look at that card. Look at anything else. Look at movement, look at this person, look at that person, look at text messages, look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the three indictments before this court. The evidence and the facts of this case are for you, the jury, to decide. Using your common sense, using your life experiences as your guide through that as you go. Before I turn to that evidence that I will submit to you ineluctably demonstrates the defendant's guilt.
Is ineluctably a word?
The text messages from Trooper Proctor are unprofessional, they're indefensible, they're inexcusable. However, as distasteful as those messages are, and their content is, I submit they had no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation that Massachusetts State Police collectively conducted into John O'Keefe's death here. As was asked of Trooper Proctor on cross-examination, these were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom, put to him as sort of a safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy, of any framing of the defendant, of any planting of any evidence, no evidence whatsoever. Why? Because it didn't happen.
What about the, make sure you tell them that he didn't come into the house?
Of any of that, beyond speculation, rampant speculation and conjecture on behalf of the defense. Two things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional. There is no defense to them. and the defendant killed John O'Keefe. Turning to the evidence, let me first talk a little bit about John O'Keefe. You heard a lot about him over the course of this trial, about his selfless story through his family and friends that loved him, including his adopted niece and nephew. You heard a lot about the lives he touched and the different people who he had friendships with. You heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a timeline. This may be a little hard to see up here. What I'm going to go is from left to right. January 28th, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:25 p.m. in the afternoon, the defendant texts Mr. O'Keefe, "Tell me if you are interested in someone else. Can't think of any other reason you've been like this." John texts back, "Nope." 2:25, Mr. O'Keefe texts the defendant, "Things haven't been great between us for a while. Ever consider that?" This is also testimony that you heard through multiple sources, whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, "Sick of always arguing and fighting. It's been weekly for several months now." He then texts the defendant, "OMG, stop calling." This is during the time frame that Trooper Garino was talking about, with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon, as she's continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m. The defendant texts John, "So you're not into this anymore." 2:34 p.m. John texts the defendant, "I am not answering, stop calling." The defendant then texts John, "Then stop starting with me." 2:38 p.m. The defendant texts John, "I'm going to grab a drink in a bit." 2:38 in the afternoon. Around 3 p.m. is the testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul, asking him to go out for a drink. This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point in which the defendant says to Ms. O'Keefe, "Wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's, with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda, tall cylinder glass, lime and a strong. 9:13 p.m., drink number 2. 9:20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. Drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall, which several individuals at the waterfall testify that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, keeping understanding that some of these drinks are not the full tall cylinder drinks, what she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, about an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Kolakithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, "Where to?" 12:14 a.m., based on the fact that she's driving, and Mme. McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe, speaks with him regarding directions, sort of going over which way to come in, Chapman Street, over Cedar Crest, as far as coming into Fairview Road. 12:15:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17:56, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to it coinciding with what you observed, the black SUV, from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a three-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time, at 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxson, and Ricky D'Antonio pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32, 34 Fairview Road, where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Miss Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. What you have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. Movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, moving up, moving up, as the witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen before you here, indicating that following that three-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, with 24.2 miles per hour for 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision.
Well, and that's pretty damn good for someone with 9 vodkas.
At 12:30 a.m., you have that second triggering event 8 minutes after the three-point turn when the vehicle's in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at 1 Meadows Ave, Mr. O'Keefe's home, when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42, Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. You recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55, the defendant texts John, "See you later." 12:59, the defendant calls, leaves another voicemail for Mr. O'Keefe. Exhibit 637, it sounded like this.
"John, I'm here with your fucking kid. Nobody knows what the fuck you want to fucking
But somebody did know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there. She had struck him there. She had left him to die. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point. 1:10 a.m., the defendant calls her parents. 1:11 a.m., she calls Mr. O'Keefe and leaves this voicemail.
"John, I'm going home. I cannot babysit Amy. I need to go home. You're fucking using me right now. You're fucking another girl. He's sleeping next to me. You're a fucking loser. Fuck yourself."
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. So the calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe, where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a plow. 5:07 a.m., the defendant leaves One Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling KPD, calling 911. Something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent, and calling your parents, and all of these other things. No calls to 911 from the defendant. While John O'Keefe is laying, freezing, and dying.
Well, how the fuck does she know?
From brain injury and a skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., the defendant's vehicle is seen on the Canton Library camera heading towards the waterfall. Seems to be sort of retracing steps. 5:18 a.m., the defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35 is when the defendant arrives at Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken taillight at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because she knew exactly where he was. She had hit him and left him there the night before. She had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives in Ms. McCabe's. 5:33 is when
He's got 30 minutes left.
Ms. McCabe and Ms. Roberts return to One Meadows Ave searching for John. 6:03 is when the defendant, no one else, spots Mr. O'Keefe's body buried in the snow.
Buried.
Exhibit 12, indicating this cruiser camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spotlight that Officer Saraf had to use in order to locate, even with the vehicle of Ms. Roberts parked right in the middle of the road. In the darkness, in the snow, in the blizzard, in those conditions, the defendant sitting in the back seat of the vehicle knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. The defendant knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to Mr. O'Keefe's phone. 6:23 and 6:24 in the morning is when Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search of evidence. 5:30 p.m. is when the defendant's vehicle arrives at the Canton Police Department cell. We circle back for a moment to Mr. O'Keefe, to his families, to his friends, and to his relationship with the defendant. You heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. And you heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Ms. Reed, that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. He even blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him. Invited her to sit down with him while he explained to their nephew Patrick about John's passing. Defendant shows up at the house, abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning grieving with the family. She left with a bag of her belongings, drove with her family there, and then took an extra vehicle in the height of the blizzard, around 1 o'clock in the afternoon, drive that vehicle all the way from Canton, where it was parked at her boyfriend's house, where she stayed over on many occasions, drove that vehicle or felt the need to drive that vehicle from Canton all the way down to her parents' house in Dighton at the height of the blizzard.
Yeah, I think I'll just stay in the dead guy's
You heard
house and
testimony
not
from
go
Aaron
with my parents.
of the text messages and the phone call on January 28th. Heard that Aaron O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Aaron O'Keefe as to what's going on with John. Aaron O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. Defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dighton. She's indicating over the phone to Aaron O'Keefe, "I don't think I'll ever see you guys." Why? If she didn't kill John, why would she say that? You heard a lot of testimony about New Year's Eve in Aruba. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Aaron via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met up. Meaning the defendant, Ms. O'Keefe, got into an argument about it, and she and Aaron O'Keefe never ended up meeting up in Aruba. Her testimony consisted from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child. The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony. About 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out. And then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off from her. Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asked him if he's okay, asked him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. And I know this is a displeasure to defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece Kaylee, John tried to diffuse, he tried to walk away, and the defendant would follow each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to see if McCarthy is eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have testimony in regard to the ring camera. Kaylee indicated in her testimony that John had had that for about a year. So during the course of 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code for the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with her father, upstairs in the home. Neither of those devices had access to the ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots. Mr. Higgins and Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe. But
I said 30 minutes before. I mean 30 minutes now. She has, I think, 29 minutes left right now.
Mr.
Sorry.
Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video. A variety of stories that the defendant tells on the morning of January 29th. There were text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call Julie Albert, because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, this is a phone call that both Mr. Albert and Ms. McCabe testify was never answered. As the phone is ringing, her husband, Matthew McCabe, reminds her that they saw the defendant and Mr. O'Keefe and the car outside of 34 Fairview. So she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a plow and that he's dead. And then indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked tail light before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he has some concerns about them driving around in a vehicle with a damaged tail light in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken tail light in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in the photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage when the search warrant is executed on February 1st. You have the text messages between the defendant and Lord Sullivan from January 29th, in which the defendant indicates to Lord Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by the defendant, Mr. McCabe, and Ms. Roberts, around 6 a.m. 5 a.m. would be about an hour before. 5 a.m. would be between that time of where the defendant is unaccounted for, heading in the direction of 34 Fairview Road, 5:18, 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitton as to SQLite databases, P-list databases, Knowledge C databases, state DB tabs, as far as all of them. Also from Trooper Garino as well. These searches were unequivocally done at 6:23, 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not deleted by a user. That is not what deleted means. Frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Cellbrite, and by Cellbrite, the person who designed that being Mr. Whitton, had to alter exactly how their software worked.
Whiffen didn't design Cellbrite.
Misinterpreting the data as he did in this case. And what did Mr. Green say? Yes. But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance, if you recall those. She asked firefighter Whitley how long to die in the cold without a jacket. He knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, in the back of the same ambulance as firefighter Whitley. You have testimony from firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have in the testimony from firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time.
Oh, fuck off with the tears thing.
Each of those first responders indicate that the defendant repeatedly stated, is he dead? Is he dead? Not, is he okay? Is he going to be okay? How is he? Any sort of questions about the medical condition. Is he dead? That phraseology repeated over and over again. And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 5:18 to 5:35. The repeated questioning, firefighter Whitney, firefighter Woodbury, asking Miss McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for. When she asks over and over again, is he dead? Is he dead? Is he dead? You have the testimony that you heard from Miss McCabe and Miss Roberts. I say them together because as far as these two women were concerned, they did not know each other really at all. The only time, as they both testified to, that they ever spent appreciably together prior to January 29, 2022, is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at a Reeboks outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece, and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th. As Ms. McCabe testified, John was my friend. I love John. He was an amazing guy. At the waterfall, Mr. Alberts said going home to have a drink with his son, Brian Jr., if anyone wants to come. Open invitation to the table. She said to Mr. O'Keefe and the defendant, you guys should come. Both the defendant and the victim indicated that they wanted to come and that they were coming. She describes the phone calls and the text messages that she receives from Mr. O'Keefe, that she's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down Chapman, going down Fairview or coming off of Chapman. That you first go down a big steep hill. It flattens out for a little bit, and then you go down a second, 2 hills going down on Chapman. Matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is reporting that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe. She's still trying to provide directions to Fairview because Mr. O'Keefe has never been there before and neither has the defendant, which is further corroborated in Trooper Garino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction. But she's giving directions and she indicates that she uses a house that Mr. O'Keefe would be familiar with, that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time, a long time ago. However, in the defendant's mind, it's so prescient on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Miss Roberts and Miss McCabe in Miss Roberts' car. She's still talking about it at that time. It's that much on her mind. Miss McCabe indicated that she looked out and she saw the vehicle initially in front of the front door, as did Mr. McCabe, as did Brian Albert Jr., as did Julie Nagel, as did Brian Nagel, and the vehicle moved up several times or several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Ms. McCabe and Ms. Roberts, and then moves up further beyond that. And I say that in the sense of it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece, Kaylee, at 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, Jen, Jen, Jen. John didn't come home, got in a fight, left him at the waterfall. The variations, different iterations of that story as it evolves.
She answered the
changes
phone
over the
because
course of
she's
that morning.
14 years old? What?
Ms. McCabe then indicates to the defendant, we saw you outside of my sister's house. Then she starts yelling, Jen, Jen, did I hit him? Could I hit him? Then they start discussing, or the defendant brings up her cracked tail. Then both Ms. McCabe and Mr. McCabe hear the defendant screaming outside of their home at about 5 o'clock in the morning, or shortly after 5 o'clock. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicates, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule, pretty strict rule in his house as far as you take your shoes off when you come in the house. So what did Ms. McCabe and Ms. Roberts both do when they're entering in that house on January 29th? They take off their boots, they get out in the snow, they take off their boots in the mudroom, and then they walk in. What did they both indicate that the defendant did that morning when she came back to the house? Walked right in with the shoes. You hear that second voicemail. It's after the defendants arrived back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that strict rule? Because she knows where he is. She knows it's not an issue, he's not coming home, because she hit him with her SUV, and she left him in the snow. Ms. Roberts and Ms. McCabe are frantically sort of running around the house looking for Mr. O'Keefe. Defendant's not. They then get in the vehicle. They drive back towards Fairview Road. And again, the defendant from the back seat of the vehicle immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight over to where Mr. O'Keefe is laying on the front lawn. You have the testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up, and you recall several witnesses testifying about that, pick him up on the scoop stretcher and they bring him over to the ambulance while they're conducting resuscitative efforts trying to save Mr. O'Keefe's life. Ms. Roberts indicated that she observed underneath only the phone, but the phone on the grass. On the grass in the area that is completely covered in snow in every other area except under Mr. O'Keefe, which I would submit indicates how long Mr. O'Keefe has been there. Now recall, around 12 o'clock or so is when it starts to snow and it starts to stick a little bit. You heard all that testimony. And I know it was a lot of testimony about snow, and a lot of testimony about weather, but there's a purpose to that. There's a point to that, okay? As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, Ms. Roberts observed some 6 hours later after it starts snowing, it's still visible only under Mr. O'Keefe where his body is, which I would submit as evidence to you as to how long he's been there. Now, on top of that, you also have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose to that as well. If you look at those, if you look at the video of the defendant crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which even Dr. Wolf would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video and the stills, you can see the damage consistent with the taillight at each and every point. You see the damage consistent with the taillight from the 507 video. You see the damage consistent from the 822 video from Lieutenant Ray from the cruiser camera video when he's pulling into the driveway. You see the damage consistent from the Dighton video at the defendant's home. You see the damage consistent from the right here, February 1st, 2022, when the search warrant is conducted, Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. The magic hair, as Mr. Jackson likes to call it. See, the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because the vehicle looked like that on the left when it was caked in snow, when Officer Barrow saw it in the driveway in Dayton as they were wading through 1.5 feet of snow walking up.
But it
Because
had
remember,
to
they didn't even
get
pull
to
into the
Dayton.
driveway because they had to have someone come down and plow it before they could get into it.
It had to go
That's
35
what the vehicle
miles to
looked
Dayton.
What you can see, however, is the damage to the taillight, to the side of that
Sorry,
taillight,
shut up.
consistent with it. So that hair, that 7/8 of an inch hair, was frozen to the side. And as you remember, the testimony from Sergeant Buchanan about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes, after it's been in there from January 29th at about 5:30 p.m. until February 1st, when they conduct the search warrant, the hair isn't still frozen as it's contained within heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted, as you can see from left to right.
And when the snow melted and the water
weather
ran off, it didn't
Also
take the hair
important, I would
with it.
submit, weather was a weapon. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. You heard all that medical testimony in relation to it, and you heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out, Mr. O'Keefe is out there in just a shirt and jeans. Now, you heard also testimony from Ms. Roberts in relation to the injuries she observed to Mr. O'Keefe. That initially on scene, there was one eye that was swollen, not the other. That's indication of the swelling that Dr. Scortibella was testifying to, and no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing at the Good Samaritan. Submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony to medical testimony to forensic testimony to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Saraf's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Saraf. You have the testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mullaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body.
Because
There's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn? Really? That's the conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak, but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before, they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments, incessant phone calls, and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to C.F. McCarthy's around 9 p.m., started drinking vodka sodas, the men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the side, same side as Waterford. Same testimony that you heard from Ms. Kolakithis, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger's seat. She said they were left the waterfall, were invited to her residence, She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night." June 2022, you have that other reporting of that other version that she now has evolved into as far as stating to Sergeant Buchanan, "Are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked." What evidence do you have of that? Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never went in the house from the testimony and the data points that you have from Trooper Green. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolokithis, Nicholas Kolokithis, Brian Albert, Nicole Albert, Brian Higgins, all indicated in their testimony, and the defendant knew, based on her questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the waterfall. The weather was a weapon. You have the testimony about the car, the defendant's car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxon. Ms. Maxon indicated she saw a male passenger, female operator as the vehicle was turned. Remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse, a 3-point turn on Cedar Crest, is then taking a right onto Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxon are taking a left on Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxon can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. And I asked him, what happened when you open the door? What happens when you open the door to a vehicle? The dome light comes on. So there's a reason I would submit, or the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle.
Then they would have seen him step out of the vehicle.
And then they're gone. Nagels, Ryan Nagel, Ricky D'Antonio, and Heather Maxon drive away from that. We have the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house where everybody's attention is drawn, Ms. McCabe is turned around facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road.
No, she was looking towards the loaf
Levinson's
of bread.
Back at Ms. Nagel, away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning. You have the testimony recalled, and you have text messages in regard to Colin Albert when he gets picked up.
Mr. Lally, 5 minutes.
Yes,
Oh, thank God.
Colin Albert, Miss Allison McCabe, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr., all indicating that it was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in early in the day, getting a couple slices of pizza. What are you doing later on? Contained within those text messages. You have testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic about those items being recovered. And in particular, the items being recovered on January 29th by that search. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level, 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found the evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I would submit is consistent, from firefighter Formati to Dr. Rice. We heard testimony regarding the defendant's blood alcohol concentration from Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. We heard Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall. You have the witness testimony in the surveillance video in regard to the forensic testimony that you have. In regard to the medical testimony, you have the sort of pattern abrasions, clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone, at any point in time ever said that Mr. O'Keefe's arm was out like this at the time that he struck and that he did a pirouette and then flew 30 feet in the air.
He kind of
12
did, though.
inches of abrasions that the doctors were, the biomechanical people were talking about yesterday. 12 inches and then 6 inches to the tail end is easily solved by this. And the dimples on his arm are, that I would submit, are consistent with the dimples on the taillight cover piece, are right around this area of the elbow. We have testimony in regard to forensics as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that taillight house, on the house. His DNA is there to the exclusion as well of Sergeant Mechanic and Trooper Proctor. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA and only Mr. O'Keefe's DNA is on his clothing and his fingernails, consistent with Dr. Scortibello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing. You have the testimony from Ms. Hartman, Trooper Paul.
I thought there was
damage
other
they
people's
observed,
DNA
dents,
on his clothing.
Scratches, 7/8 of an inch hair. You have the testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Valier and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes, all consistent with pieces of taillight that are found within his clothing. Ms. Gilman, if I could. 605, this is what this vehicle looks like backing up at that speed for approximately that distance.
Shut it down, Judge.
Years and years ago.
That's what it looked like backing up at the
practicing
speed,
in
huh?
Norfolk County in Braintree, what is now Quincy. I eventually became a far smarter man than myself. Eventually became president of the United States. His name was John Adams. John Adams once wrote, "Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I literally have one sentence.
Nope.
1 sentence I'll give you.
From that facts and that evidence, I would submit and electively demonstrates her guilt on each of the indictments before you, and I would ask that you find this. Thank you.
All right. Thank
Oh
you.
wow, that was
Jury,
less
I
than
have
stellar.
my instructions on the law I'm going to give you. My guess is it's probably about an hour. I'd like to start it now, but does anybody need a short break? We can take a short break. Okay, we'll come back in 5 minutes.
You are muted.
I wish someone would have muted him like an hour ago. All right, people, that was it. That was the closing. He made a lot of emotional
Hey there,
arguments.
Karen Reed,
Oh, be
trial
quiet.
watchers. You know what a lot of the trials we cover remind me?
Reminds me I don't want to listen to you. He made a lot of emotional arguments. He made a lot of the argument in Aruba a month before this. He didn't address any well. He addressed a bit of the scientific evidence, his scientific evidence, if you can call it that. He didn't counter any of the evidence from the defense. He didn't explain why that couldn't have happened that way. He barely mentioned Proctor other than to say he's a POS. I thought it was a less than stellar deal. And he was just wrong and or lied, however you want to interpret it, about several things he said. And I think if the jury is looking critically at it, they're going to notice, they're going to recall things that are contradictory to what he said. And again, if they remember his opening statements, they fixed the time of death around 12:40 to 12:45. They didn't explain how she couldn't have been home and logging into his Wi-Fi at 12:36 before anybody puts the accident. Well, that's it. And the stories he's telling about, I hit him. She said this, she did that. It's all from the witnesses that the defense were saying are unreliable, untrustworthy, and are the ones that are interested in covering up any wrongdoing. So yeah, he was all relying on the, I saw the lump. She never testified about seeing the lump in the snow to anyone ever before that day. I mean, things like that. It was all the one statement from one witness. That's what he's relying on. Several of these quote unquote facts he brought up as to what was said, what was did, who called. It was all just the statements of his witness. Didn't explain the butt dialing. Didn't explain all the texting and calling that was going on. I didn't like it. I wasn't persuaded by it. I was annoyed by it. I didn't like. I'm just trying to think how a critically thinking juror might look at this. He didn't contradict any of the scientific evidence. Because these guys went so quickly and because there was no break between them, I've got a ton of super chats here to read. So talk amongst yourselves for a minute here, people, and let's see what y'all had to say during the course of the statements. Island with the $5. I have big plans to forget the McAlberts. This was the last one we read. Mistrial is not acceptable at this point. It will break my brain. Thank you, Island. Buddha Berries with the $5. Thank you for those Aussie bucks. Unpopular opinion. I'd rather him lean into recon evidence and crappy crime scene handling and not so much into the conspiracy narrative. I think there was a good balance. He got off to a little bit of a slow start. I thought Jackson did with all of the the quotations, the lengthy quotations, and clearly kind of reading from his script. But then he got more natural with it. He got more comfortable. He got into his groove. He mentioned the possibility of the cover up. Then he hit the heavy evidence, the scientific evidence. I thought it was a good balance, but. I could be alone in that opinion, but it's interesting to see how we all have different opinions as to the quality and degree to which people should have done something or shouldn't have done something in their closing arguments. Aussie Wombat with the $15. We got lots of Aussie bucks coming in. Treats for Strawberry and Yoda. They had their treats. They had lots of watermelon, didn't you guys? And why we don't have dogs? People were, I think it was Mary was saying, where's the doggo cam? There's no dogs on doggo cam right now. They're all on the other side. The camera's over here. They're all over here on the floor. Oh, hey, speaking of the devil, Strawberry it's almost as if she can read my mind. There's Straubs, sort of. Hey, what's up, buddy? Treats for Strawberry. Yeah, they've been eating watermelon here with me. I've been feeding them watermelon. I wish I was drunk with the €2. How are we, lads and lasses? Hope all is well. All is well, I think. I think things are going well. Thank you very much. Irish, I was drunk. Jonathan Irwin with the $2. Chat didn't post, got canceled. Here's $2. Thanks, Jonathan Irwin. I wonder what the chat that didn't post said. Did you say the naughty words, or was it just one of those things? And the Vlad Vox Production Studios is the newest member. The newest member of what? The newest member of something. I'll assume I was gonna say the lesser tier, but no. Vlad Vox Production Studio is the Bent Halos and Broken Wings level membership. Thank you so much, Vlad, for showing your support there, and I hope you'll be around for a while. Thank you so very, very much. I appreciate that. And Vicky Heatherly gave us the £1.49 super sticker. Where's the super sticker? It is a dog. It's a cute little dog super sticker. Thank you so much for that. And Brian Miller with the $2. Funny, they charged her with OUI, but not the cops. Well, see, that was the thing, is they didn't specify which driving under the influence she had done. Was it after the bar? Was it the 5 o'clock one? Was it both? Why wasn't it 2 separate counts? There was no explanation at any point during this trial or no, of when she had her last drink. She could have, for all we know, she could have been buying those drinks and giving them to other people in the bar. There was no testimony that I recall saying that she ordered all of those vodkas and she consumed them herself. While her boyfriend is not coming home, while he may be out with, let's not start that. Let's not start that, dogs. Thank you. Well, they're too close. Hi. We'll look at Yoda here. Her boyfriend's not coming home. She's trying to find him. He's not responding to the text. She's getting pissed. Why not have a few drinks? I probably would, but that's just me. I thought that was a big problem. But that also doesn't really answer your question. Why didn't all the cops that admitted on the stand to driving after 6, 7, 8 beers, they didn't get charged? Gary Zelle with the $10. What's your prediction? Well, let's look at your predictions here first. The like and subscribe poll is up. 630 concurrent viewers, 578 likes, and 1,000 votes. We've got 1,043 votes. People, 500 of you have cheated. 500 of you have taken the like and subscribe poll without liking. Repent and get down there and smash that like button, people. How dare you? How dare you take the like and subscribe poll without liking and or subscribing? We didn't get 1,000 new members because hit that subscribe button. Please hit the subscribe button. You've been here. This is what we do. And starting next Monday, we're going to take the week off, and well, not the week off of streaming, but the week off of trial streaming. We're going to have a normal remainder of this week, I guess. We will start with the Alec Baldwin trial on Monday. Monday's the beginning of the Alec Baldwin trial, so stick around for that. Hit that subscribe button and get all the notifications and whatnot, and hit the like button. Here we go. The question for today was, Karen Reed will be found what? Karen Reed will be found. 5% of you said guilty. So out of 1,000 people, that's about like 50 of you think she's guilty. All right. 85% of you. All right. That's an overwhelming number. Say 85% of you say not guilty. 10% of you say hung jury. 1 in 10. My prediction. Oh, see, I hate predicting what juries do, which is actually problematic, I think. Because there should be some predictability. You should be able to sort of kind of guess how things are going. But I clearly think she should be found not guilty. What do I think the jury is going to do? Oof. All right. I hate making predictions. I never make predictions, but you asked. So I'll go out on a limb here and say the majority of my gut is telling me not guilty. There's a small little section that says someone might be stubborn and hold out. And I think the judge is not, because we've seen trials where the judge goes, well, yeah, you discuss this for 5-6 hours. You can't come to a conclusion. All right. It's a hung. That's what they did in the YNW Melly trial. They didn't deliberate for very long at all before the judge said, all right, hung jury, mistrial. I think if there is an indication that they're at an impasse, the judge is going to strongly urge them to continue their deliberations. If it could go a day or two, I don't know. But I strongly think she will urge them to come to a conclusion because she doesn't want a hung jury and a mistrial. So that's my prediction. The majority of my gut tells me not guilty. I hope that's the outcome. Where are we here? Mug Life Stingy. What's up, Stinge, with the $2? Lally sounds more like CD defense than prosecution. Again, I mean, some of you were saying it was better than his opening. To me, it was kind of about the same, disjointed. He was jumping back and forth in the timeline repeatedly, just throwing out random, and he actually looked bored himself giving that. He looked bored himself. SAPXZ, only complaint for defense closing. Wish they said something like, we don't know exactly how he died. You don't have to believe our theory, but the prosecution theory is not physically possible. Yeah, some specific statement like that may have helped.
All right,
I got
jurors.
banned on Twitter for 7 days because Mike Pence said something about a
Thank you for
miscarriage
serving
of
on this
justice.
jury and for being so attentive.
responded that
You'll
he should
soon
have been a
deliberate for the
miscarriage.
purposes of reaching a verdict in this case.
All right,
But
here's the
before
jury
you do
instructions.
that,
It's going to take about
it's
an
my
hour.
responsibility to give you instructions concerning the law. The instructions are divided into 3 parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations.
Finally,
I will
mark off
try to
heavy
make
Boston
sure
accent on your
that
bingo
my
card.
oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud.
Oh,
You must
interesting.
take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part 1 of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental
let's
rule that
begin it.
applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. I will explain reasonable doubt in just a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged, or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions, and the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law to that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with other jurors. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations, and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limiting instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reed had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were in fact John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and or the defendant. If you do not find it is more likely true than not that John O'Keefe, Karen Reed, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can infer from the evidence that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witness testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of these witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the assumed facts are true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. Now, you have the same powers with respect to the exhibits that you have and the testimony of the witnesses. Look them over and decide the weight, that is the value they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it is written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what the exhibit purports to show and how much weight, if any, you give each exhibit. Now, you've heard me talk about the sources of evidence in this case. Those are the tools that we have to decide the case. Now, with the evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household, a child, roommate, or spouse, hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I have just described. You may have noticed that the defendant did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that the defendant did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. All right, that completes my first part of the instructions. Now I'm going to turn to the elements of the charges
All
against
right,
Ms.
these are the
Reed.
important part. This is what they have to prove
The
beyond a
Commonwealth
reasonable
has
doubt.
alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has three subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. You'll have both these choices on the verdict slip. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point. Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element. Here, the defendant must have intended her acts in the sense that they were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition and how well the defendant could see and could control the vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. Save a little time for you. As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Now that completes the second part of my instructions. I will now turn to the final instructions. In order for a jury to return a verdict, that is to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are still 14 of you. To avoid the need for a new trial, if one or more jurors becomes ill or has to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. However, when you begin your deliberations, the law of Massachusetts is that there can only be 12 jurors. Therefore, at the conclusions of my instruction, the clerk will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted because,
That would
as I've
actually
indicated,
suck
it
to
is
be there
important
for
that we have
8
extra
weeks.
jurors in the case of emergency. If we did not
And say, "All right,
impanel
go
extra
home."
jurors and a juror became ill or for some other reason had to be excused, we would have to try the case all over again with the new jury.
8, 10 weeks, whatever it is.
In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start their deliberations all over again from the very beginning. Therefore, it is important that the alternates not discuss the case with anyone, including each other, for if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not influenced by anyone else. Now, different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own foreperson. In Massachusetts, the judge is responsible for selecting a foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations, however, in that sense is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400. Would you be our foreperson, please, sir? Thank you. When you return to the jury room to
Juror
deliberate,
number
the court officers will
400.
deliver to you
Right.
all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case.
Don't talk to the clerk
Further,
of court either.
I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartial impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not consciously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to see counsel before we reduce your number to 12.
Okay, while she's doing that, Rocco asks, why can't the jury get a transcript? One, the final transcripts aren't available until long after the trial. They have the temporary edited isn't the right word, uncorrected version, which we're getting from the lady with the fighter pilot mask or feedback, depending on what you want to call it. But the jurors are supposed to rely on their memories, their notes, and the exhibits. Giving them the transcripts again, that would essentially amount to a witness testifying twice. They would get to hear the testimony again. It's just something that's never done. What percentage of the instructions are usually boilerplate? Almost all of them. And Mr. O'Keefe, can you put your junk away, please? Yeah. Yeah, they're mostly boilerplate, like all the first part and all the last part. That's all just standard form. And even most of the stuff in the middle, the elements of the crime, that's almost always all boilerplate. They'll argue a little bit about the special language and a few alterations, a few things like that. They did it yesterday, and it took them a little over an hour to reach an agreement as to what changes should be made. So that's a pretty good indication the wording is standard. It's mostly all boilerplate. It's like I said, it's standard. It has to be done. It's important. It's one of the most important parts of the entire trial, saying what the law is and how to interpret it. All right. Once they decide who's leaving and who's not, and they go away, we'll talk about the elements a little bit. Then I'll try to get some sleep. But until then, let's just watch. We did have Rob Bryce came into the member who's been a member for 6 months. Thank you so much for the 6 months of your membership. It's deeply appreciated. Clean and sober crew. I think Karen Reed should be found guilty because after cases like Zach Anderson, I don't have much faith in the
You
legal
are unmuted.
system, especially
All
with
right,
biased
so
judges.
Mr. Clerk, will you choose the alternates, please?
How do they choose the alternates? A lot of times they draw names out of a hat or numbers out of a hat or things like that. I mean, literally. Okay, they have numbers. Oh, it's a bingo. They're playing bingo.
Could the juror sitting in seat number 3, who is juror 79, step down and take your place as an alternate? And the juror sitting in seat number 2, juror 14.
All right. So, ladies and gentlemen, we need to swear in the court officers. They're going to be in charge of you during your deliberations. I suggest that you listen to the oath that they are taking so that you can be aware of their responsibilities. Now you can swear them, Mr. Clerk.
You swear that you will keep this jury and alternates in some separate but convenient place until they agree, that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they are agreed, nor suffer them to disperse until they're discharged of their verdict, except by further order of the court, so help you God. Thank you.
All right. So, jurors, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you have heard here in the court during trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may now retire and deliberate your verdict.
Jurors, this time taking your notebooks. All rise, follow me.
All right. They are going into their room to deliberate Karen Reed's fate. She's like, oh, thank God I don't have to talk into this feed bag anymore. All right. Let's, anything else to say, Bev? Probably tell them to stick close to the court. Be ready to go in an hour's notice or something like that.
Maybe see.
All right. So, counsel, I'll give you a few minutes to work with Mr. McDermott on the verdict slip, and then I'll come back out.
Thank you, Your Honor.
All rise for the court, please.
So involuntary is that?
No, involuntary.
All right. So now that they're just getting the verdict slip ready to give to the jury so they can go through and check off all the little boxes. They literally have most of the courtrooms will have check boxes where you can literally just go down and check this, check that for the elements.
Hey there, Karen Reed, trial watchers.
there.
You know what a lot of the trials we
All right, let's put him down here. Judge is going to come back here in a bit, probably say something to them. It'd be kind of fun if they were like, "Hey, we're done. Can we have the jury? Can we have the jury slip? Can we have the verdict forms now, please?" All right, Mexican Vader. Let's run through the bingo card. See if anybody got bingo. What I have is dog cam, broken tail light. Judge calls for sidebar. Lolly got off a sort of. Ceiling Dion. Lally also got, he mentioned first responder. Internet search. Forced to admit a lie. I gave us that one because they lied. Bad weather. Body on front lawn. They mentioned the dog. Marks on O'Keefe. The judge has a heavy Boston accent and a nervous prosecutor cough. Not laugh. Nervous prosecutor cough. According to my findings, there was no sigh from Judge Bev today. There was no questioning to cut off. No lip smacking witnesses. No witness asking about rephrasing things. There was no who, if anyone. No what, if anyone. If anything, thank God. No one to cross-examine. No one to get cross-examnesia. Judge came close with Darth Vader mic breathing, but no. Lawyer calls for sidebar, and there was no siren outside the court today. And Aaron asks the very important question. Are you going to wake up in the middle of the night if a verdict comes in? I'm trying. There's a very, very limited number of people on planet Earth that have my phone number. One of them is our very own Flux. Flux is going to keep watch here, and there's a little bit of time where she's not going to be available towards the evening, but most of the day she should be available to call me and wake my ass up if they come back with a quick verdict. So the answer is I hope so. The answer is I hope so. That's the plan. I'm gonna have my phone on, and I'm not gonna have it on mute or vibrate. So I'll get the announcements. The only other thing I can suggest is, despite Flux attempting to wake me up or planning on waking me up, I don't know, light up my Twitter DMs and until the pinging wakes me up. I guess that's the best I can do. And I know Danny's streaming it as well. Danny's got my number, so I'm going to ask her to wake me up too. We'll see how he goes. We'll see how it goes. All right, that's it. Hey, you got a bingo. I didn't. 2 full bingos. I got 0 bingos out of all of that. There's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 spaces out of 25 that are open. And I got 0. I got 0 bingos. So screw that. No, I'm not a heavy sleeper. I'm a very, very light sleeper, actually, especially like if I know that I have to wake up for something. No. We're going to talk about this, Lady Autumn Sky here. We're going to go over the elements of the crime. There's actually one thing that could make this happen very, very quick. So, anyways, like I said, that's just in case. Light up my DMs on Twitter, and that should wake me up. Who would you rather be woken up by, Danny or Flux? Both. Hey, why not? Both. Right. So let's talk really quickly here about the elements of the crime and what they have to prove. What does the jury have to decide? First of all, as she said, it has to be proof beyond a reasonable doubt. And reasonable doubt is after comparing and considering all of the evidence, you have an abiding moral certainty that she did what she's accused of. Now, if you have a reasonable doubt, the defendant has to be acquitted. And that's more than a strong probability that the defendant did. It has to be more than a strong probability the defendant did it, but it's not beyond all possibility. It must be reasonable and morally certain. Now, she's been charged with second-degree murder. So it's assault with intent to murder, basically is what it is. That's the main elements of the crime. The second-degree murder, assault with an intent to commit murder. And to do that, there's a bunch of elements. But all of these, there's lesser included offenses. If you can't prove this, you can still prove this. If you can't prove this, you can still prove that. If you can't prove that, you can still prove the other thing. So all of these kind of go down. And you start with the most serious first, and if that's not proven, you go to a lesser included. If that one's not proven, you go down until you get to the bottom. Now, the one thing that all of these charges, except for the leaving the scene, well, I guess except for leaving the scene of an accident, I guess, all of these things have one thing in common. That is, she killed him. If they all say, we don't think she killed him, it's over. It's done. There's really nothing else to discuss. So that's the first and most important question, because that's something that's common to all of these. So if they say, yeah, we don't think she killed him, that's a very quick verdict. Well, I mean, however long it takes them to reach that consensus. So that's the first thing. The defendant caused the death. If they don't think the defendant caused the death, it's essentially over. So let's look at the second degree murder. She had to have caused the death. Again, that's just there. She had to have caused the death. Basic, straightforward. And the cause of death has to be through a natural and continuous act that results in death. So did they cause the death? And did she intend to cause the death? She had to have intended to murder John O'Keefe. So did you intend to cause death or grievous bodily harm? And that basically boils down to, you have to consciously and purposely intend to cause the death. Do you think Karen Reed consciously and purposely intended to kill John O'Keefe? The alternative to that is, did she intend to cause grievous bodily harm, or to cause serious harm that resulted in the death? Or has she done something that an ordinary person would know would cause the death, which is, an ordinary person would an ordinary person have to intend to do it? What did she understand about it? Did she understand that she was going to kill him? Or a reasonable person would have known that it created a plain and strong likelihood of death? I think no across the board. I don't think she caused the death. I have reasonable doubt that she caused the death. But let's just assume that she did cause the death. Where do we draw the line on the charges? Did she intend to do it? I don't think they showed intent at all. So I would say not guilty of second-degree murder. There was no conscious intent to cause the death. There was no conscious intent to cause grievous bodily harm. And I don't think a reasonable person would have known that whatever she was doing would cause a strong likelihood of death. So that let's put that one aside. For me, I don't know, maybe you think that all those elements have been met and she should be guilty of second-degree murder. Then there's the lesser included. Okay, if you don't think any of those apply, if she didn't have the intent, et cetera, was it vehicular manslaughter? That's the lesser included. And to prove that, you have to prove, was she operating a motor vehicle? Okay, she was operating a motor vehicle at some point in time. Yes. The defendant operated the motor vehicle on a public street. Yes. The defendant was under the influence of alcohol. And I thought it was interesting that a blood test itself is not sufficient to prove that. So was the defendant under the influence? Now, this is at the time she caused the death. Again, we are assuming here that she caused the death. So at the time she caused the death, was she operating under the influence? Well, that all depends on what time she caused the death. And I don't think they did a very good job of proving that she was under the influence at the time. They proved that she had a point, was it 2:08 or whatever it was, at 9 o'clock in the morning when they did the blood test. But did she drink half a bottle of vodka immediately before she went out looking for him? Don't know. So I don't think they met that burden of proof on that. So that's one element. And the defendant's action was reckless. Was driving under the influence reckless? And did the defendant cause the death? So you have to decide, was she under the influence and did she cause the death? And was it reckless? Now, if you say no to all of those, then you go to the lesser included, involuntary manslaughter under the influence. Did the defendant, I guess to any of those, if you answer no to any of those, you go into the lesser. Did the defendant cause the death? We're assuming yes. Did they intend to cause the death? So again, intent is another important element of this. Did they intend to cause the death? Or was the conduct wanton or reckless? And that means a reasonable person, even if she didn't intend to cause the death, was it such that a reasonable person would have realized that it was a dangerous conduct beyond mere negligence that would result in death? If you say no to any of those, or if you say no to those, then it goes down to the lesser included defense of motor vehicular homicide. Now, this only comes into play if you're not convinced that she's guilty of second-degree murder, she's not guilty of the involuntary manslaughter under the influence, and you're convinced that she is guilty of motor vehicular homicide. And what that is, you have to prove she operated the vehicle. Yes. You have to prove she operated the vehicle on a public road. Yes. Then it comes again to the while operating under the influence. Let's say yes for the sake of argument. So if you think, she operated the vehicle, it was on a public road, and let's assume she's operating under the influence. Okay, if you meet all three of those, did she operate the vehicle negligently in a manner that might have endangered people? A reasonable person wouldn't do it. Intent doesn't matter. This is one crime that intent doesn't matter. And I would say that if if you assume that she is responsible for his death, she caused his death while operating the vehicle on a public road under the influence, I think that you automatically meet the in a negligent manner, because I think a reasonable person would conclude that operating a vehicle under the influence is in and of itself a negligent act. So this one, if you think she caused the death and you think she was operating under the influence at the time she caused the death, there you go. I think she's guilty on this one, but I don't think she caused the death, and I'm not sure she was under the influence at the time that she didn't cause the death, if that makes any sense. Then if you throw away all of those, and then there's just leaving the scene of an accident resulting in death. So if you think that caused the death and she left the scene of the accident, regardless of whether she intended to cause the death, regardless of not being drunk, if she was stone cold sober and caused the death and she left the scene of the accident, she's guilty of leaving the scene of an accident resulting in death. I think if you believe that she caused the death, that might be the best they get. I would say her biggest risks are leaving the scene of an accident resulting in death and vehicular homicide. I think those are her two biggest risks, the lowest two crimes. And then that's kind of it. Where do you guys sit? It's up to you to decide. Now, Great Success says something here that I'm going to take exception to. I'm not sure why Great Success continues to yell in all caps all the time. It's totally unnecessary. Yes, she operated a vehicle under the influence. They proved it with the bar receipts. That I don't think is correct for a few reasons. They showed she purchased it from the receipts. They didn't prove she consumed it. I don't think they proved that she consumed the alcohol. She purchased it. I buy drinks for friends all the time. If I was out and people looked at my bar tab and went, "Holy shit, look at these things he bought. He should be dead." That's what they would be thinking. So I don't think they proved that they consumed it. That's number one. There's a problem with purchasing and consuming, totally different things. And add to that, at the time of the death, she's not charged with DUI. She's not charged with simple DUI. That's not a charge she faces. They're all surrounding the death of John O'Keefe. So you have to first believe she caused the death of John O'Keefe by running over him with a car. And then was she operating under the influence at the time she ran over him with the vehicle? Was she under the influence at that time? So I think that argument is flawed on two fronts. Did she consume everything that she purchased? And was she drunk at the time she killed him? I don't think she killed him anyway. So, all right. And see, this is the thing is, let's assume she did drink nine vodkas, whether it was mixed with tonic or cranberry juice or whatever the hell else. Let's assume she consumed 9 shots of vodka in the space of what was about an hour and a half. That's a lot of alcohol for a little woman like her. If I had 9 shots of vodka, I know that I probably couldn't reverse in a straight line with only a 10-degree alteration of the steering wheel for 67.5 feet or whatever it was at 24 miles an hour in a blizzard. That's some pretty good driving for someone who is 3 or 4 times, 3.5 times the legal limit. So yeah, I've got a lot of problems with that. And that's coming from life experience and common sense, which you're allowed to use. I'd be saying, well, if I had 9, I don't think I could back up like that. So that's just my thoughts. All right, peeps. There we go. That's where we are. The jury is now deliberating. We're going to leave it up to them. We're going on to jury watch, onto verdict watch. So what's going to happen now is I'm going to wrap this up. I'll send you. Where am I going to send you? I'm probably going to send you over to Andrea Burkhart. Let's see. Who do we get to send you to? Bear with me here for 1 second. You 549 people that are here. And while I'm doing this, just make sure for little old me, for little old Lorax, I speak for the tubes. I speak for the law tubes. Get down there and hit that like button. And if you haven't subscribed already, I would just be tickled. 16 different shades of pink, 45 different shades of broken taillight. If you would do me the honor of subscribing to the channel and hitting the notification bell and whatnot, that would make me a happy Lorax. All right, where can we redirect you to? Who's going? Andrea Burkhart is going. Danny's no longer going, so we're going to go over to Andrea. There we go. Right. We are locked and loaded to send you on over to Andrea. Make sure you tell her that Legal Vices sent you and listen to her analysis. She's sharp as a tack, but whatever you do, if they come back with a verdict, leave her and come back to me. Just leave her and come back to me. All right. As I was saying, we've got the like and subscribe stuff going. Let's see what the like and subscribe poll says, shall we? I closed that dang window, so now I got to open it up again. Where are we? All right. We're working our way towards 78,000 subscribers. We've currently got 77,165. Sure, some of you haven't subscribed, so let's push those subscriber numbers a little north. Why not? That would be awesome. Thanks. The like and subscribe poll is: how long will it take the jury to reach a decision? 27% of you say 0 to 2 hours. 49% of you, it's almost half, say 2 to 5 hours. And 14% say 5 to 10 hours, and 10% of you say more than 10 hours. So nearly half of you say 2 to 5 hours. Well, that's good because that'll give me some time to sleep. Unless it's like 2 hours and 10 minutes, then I'm screwed. All right, and the last thing I want to do, and I'm going to end the poll here now with 49% of you saying 2 to 5 hours. The last thing I want to do, here is your final chance to vote on how you think the outcome is going to be. Put a 1 in chat for guilty of any of the charges, or a 2 for completely not guilty across the board. 1, guilty of something. 2, not guilty of anything. Do that real quick. Yeah, as Flux points out, lol, you bought drinks for other tables in Vegas. That I did. I bought drinks for bartenders too, and the other place we went, I buy stuff for other tables. Of course, there was 4 hot women at the other table, so why wouldn't I? Just saying. 2, 2, 2, 2, 1, 2, 2, 2s. The 2s have it. You guys are all in the 2s. There's a few 1s scattered about. Great success is one of the 1s. You can't vote twice. Great success. 1 + 1 = 2. So there you go. All right, folks. Silent. She was not charged with DUI. That's the thing. She wasn't charged with driving under the influence. She was charged with the lowest thing she was charged with in that regard is motor vehicle homicide. The only thing other than that was leaving the scene of an accident resulting in death. So, yeah, she wasn't charged with DUI. All right, folks, let's go on over to Andrea. Andrea Burkhart is going to probably give you some comments. I just want to say super thanks to the mods for sticking through this for 5 hours, and thank you to all of the super chats, the monthly membership chats, the gifted memberships. Sonia or Chris ended the evening as the vice racks of the day with 15 gifted memberships and a few other super chats here and there. Thank you, everybody in chat, for the Vice Squad chat. As I always say, it is the best chat on the entire YouTube platform. Hands down. No questions. You guys completely and totally rock. Love all of you. We will see you either with a verdict sometime in the next few hours, or we'll start jury watch again tomorrow. And stay tuned, because let's assume that it comes down. I'm going to try to have some people on tomorrow to talk about the verdict, if there's a verdict today. Thursday, we'll go back with our retro trial. Friday, I have no idea yet. And then next Monday, there'll be some things going on that you're not going to want to miss. So, all right, everybody, take care. We'll see you when we see you. Stay tuned, stay alert, hit that notification bell. Excuse me. No, I haven't had anything to drink. Hit that notification bell so you get the notification if and when I set up the verdict stream. Take care, everybody.